Hello, I'm Stephen Koprince, Managing Partner of Koprince Law, LLC. I'm here today with an update on the Kingdomware SDVOSB and VOSB Supreme Court case. The VA and Kingdomware, as you may know, have not agreed on much in recent years, but they do agree on one thing. Kingdomware's pending Supreme Court case should not be dismissed as moot. As you may recall, Kingdomware has been fighting a long-running battle with the VA about whether a 2006 statute requires the VA to prioritize contracting with veteran-owned companies, even when the VA would prefer to order from non-veteran companies using the GSA schedule. Kingdomware and the government were set to present oral arguments to the Supreme Court on November 9, 2015. But just a few days before oral arguments were to take place, the Supreme Court asked both sides to address a technical question: whether the case should be dismissed as moot. Specifically, the Supreme Court asked whether the contracts at issue had been fully performed, and if so, whether that meant that there was no live controversy for the court to resolve. Well, those briefs are in, and Kingdomware and the government both agree the case is not moot. In its own well-written brief, Kingdomware argues that the case falls into an exception to the ordinary rules of mootness for disputes that are capable of repetition but evading review. In other words, Kingdomware argues the contracts at issue here, which are primarily low-dollar, short-duration GSA schedule orders, simply don't run long enough to still be ongoing by the time a new case would be litigated all the way up to the Supreme Court. Additionally, Kingdomware argues that the injury that it's complaining of at the heart of its case, that is, the VA's decision to order off the schedule without first applying a preference for veteran-owned companies, is very likely to be repeated, and the VA essentially agrees it's going to keep doing this unless someone tells it not to. In its brief, the government takes essentially the same position as Kingdomware, stating that the case is not moot. Like Kingdomware, the government says the case fits into that exception for disputes that are capable of repetition but evading review. And in that context, the government essentially says the VA is going to keep doing this unless the Supreme Court rules otherwise. Now, the VA concurs that the GSA schedule orders at issue here are typically short. And even when an order lasts for a longer period, that length is typically due to the exercise of options. A potential plaintiff, someone who might be filing a case on this very issue in the future, has no way of knowing whether the VA will actually exercise those options and whether the contract would still be ongoing by the time it were to reach a Supreme Court. On December 1, 2015, Kingdomware and the VA both filed short additional briefs in which they again agreed that the case should not be dismissed as moot. The case has now been fully briefed, and it's up to the Supreme Court to make the call. Hopefully, since both sides agree that the case is not moot, the Supreme Court will allow the case to proceed and will ultimately issue a decision. If the Supreme Court does allow the case to proceed, the court will likely reschedule oral argument for some time in early 2016. Here at Koprince Law Reports, we'll keep you updated on all the latest in the continuing Kingdomware saga.